In a world governed by increasingly complex political, legal, and technological systems, it is essential that individuals and groups understand not only their rights under international law, but also the obligations that their governments are bound to uphold. Among these obligations are peremptory norms, or jus cogens, which form the non-derogable foundation of the international legal order. These obligations supersede domestic law, political convenience, and statutory constructs. This write-up will provide a comprehensive understanding of the international order, explain the legal doctrine of peremptory norms, and show how individuals can lawfully claim and invoke these obligations when their country fails to uphold them. 1. Understanding the international order. The term international order refers to the system of rules, norms, institutions, and agreements that govern relations between states and other international actors. It includes entities such as the United Nations, the International Court of Justice, and a body of legal instruments like the International Covenant on Civil and Political Rights, ICCPR, the International Covenant on Economic, Social, and Cultural Rights, ICCPR, and the Vienna Convention on the Law of Treaties. At the core of the international order is the principle of sovereign equality, meaning all nations are equal under international law. However, sovereignty does not grant immunity from international obligations. States voluntarily enter into treaties, but once ratified, these instruments carry binding obligations that cannot be selectively ignored. 2. What are peremptory norms? Jus cogens. Peremptory norms of international law, jus cogens, are those principles that are recognized as fundamental to the international community. They are non-derogable. They cannot be set aside even by agreement. Universally binding. All states are bound, regardless of ratification status. Hierarchically superior. They override conflicting national laws and treaties. Examples of jus cogens norms include the prohibition of genocide, the prohibition of slavery, the prohibition of torture, the right to self-determination, the right to recognition as a person before the law, ICCPR Article 16, the freedom of thought, conscience, and religion, ICCPR Article 18, the Vienna Convention on the Law of Treaties, Article 53, codifies the concept of jus cogens, stating that any treaty conflicting with a peremptory norm is void. 3. Binding nature of peremptory obligations. When a state becomes a party to an international treaty such as the ICCPR, it assumes a binding legal duty under international law. In the case of jus cogens, these duties are binding regardless of ratification. Moreover, Article 2 of the ICCPR requires states to respect and ensure the rights recognized in the covenant and to provide effective remedies when violations occur. The obligation is twofold. Respect. States must not violate these rights. Ensure. States must take positive steps to protect these rights from third-party interference. Failure to meet these obligations constitutes a breach of international law and may expose the state to legal action before international bodies or courts. 4. Domestic law cannot override jus cogens. The doctrine of pacta sunt servanda, agreements must be kept, is fundamental to treaty law. However, it is subordinate to jus cogens. No government can pass a law or enforce a policy that overrides peremptory norms. For example, no national statute can lawfully force individuals to obtain state recognition before being considered legal persons, compel belief systems, or suppress conscience, override the right to self-determination. If it does, that law is legally invalid and void under international law, regardless of its standing domestically. Claiming your country's peremptory obligations. Claiming peremptory obligations is not just a theoretical concept, it is a lawful action grounded in international legal doctrine. Individuals can do this through multiple channels. A. Direct invocation refer to relevant jus cogens norms when communicating with public officials, courts, or tribunals. Cite treaty provisions, particularly the ICCPR, ICSCR, and Vienna Convention. B. Legal instruments file a writ of mandate or injunction based on violations of non-derogable rights. Present arguments asserting the supremacy of jus cogens over conflicting domestic law. See international communications. Submit formal communications to UN special rapporteurs or treaty bodies. Raise issues before the Human Rights Committee or other monitoring bodies. D. Documentation and evidence. Keep written records of rights violations. Document government refusal to engage with or uphold peremptory norms. 6. Real-world application and challenges. Many states attempt to sidestep international obligations through statutory constructs. For example, forcing individuals to apply for legal personhood, denying recognition unless registered under state law, or suppressing beliefs that challenge institutional frameworks. However, the strength of jus cogens lies in its supremacy. Courts, once properly confronted, are required to uphold these obligations, even if doing so exposes domestic contradictions. Still, individuals may face resistance, denial, or bureaucratic deflection. This is where persistence, proper framing, and clear evidence become critical. The more people assert these rights in lawful, structured ways, the harder it becomes for governments to maintain the illusion that these rights are optional. Ethical responsibility and collective power. Under the Declaration on Human Rights Defenders, individuals and groups have the right and the duty to promote and protect universally recognized human rights. This includes the responsibility to hold states accountable, share knowledge of peremptory norms, challenge institutionalized denial. The international legal order is not just for states. It exists to protect individuals and communities. The power of that system grows stronger the more it is invoked by those it was built to protect. Conclusion: understanding and asserting your country's peremptory obligations is not an act of rebellion. It is an act of lawful insistence. It is the rightful exercise of conscience within the structure of international law. The legitimacy of any government rests not on its power to enforce statutes, but on its willingness to uphold the foundational principles of justice that transcend all law. By learning the international framework, invoking it clearly, and refusing to yield your recognition to the permission of others, you activate not only your rights, but the strength of the international order itself. This is what it means to be eternally aware. At the foundation of any just society lies a singular, unshakable truth. The rule of law stands above the government. No matter how powerful a government may appear, it is not sovereign in and of itself. It is bound legally, ethically, and institutionally by the rule of law and by the principles of justice that are embedded within it. In Canada, this is codified through the Constitution and its Charter of Rights and Freedoms, which themselves are not merely domestic instruments, but extensions of international human rights obligations. These instruments provide the operational framework to access, protect, and assert what are known as absolute rights, those rights that are non-derogable, non-negotiable, and beyond the reach of legislative override. This write-up explores how the rule of law limits governmental authority, the role of the Canadian Charter in defending absolute rights, and how individuals can access the operations of law that activate their international protections. It also highlights a critical truth. Unless individuals actively claim and stand under their absolute rights, the government will continue to impose additional obligations, statutory burdens, and artificial restrictions on their lives. 1. The rule of law. Supremacy over government. The rule of law is not a slogan. It is a binding constitutional and international principle. In Canadian jurisprudence, it means that all persons and authorities, including the government, are subject to and accountable under the law. Laws must be publicly promulgated, equally enforced, and independently adjudicated. The exercise of power must be consistent with legal authority and principles of justice. In the Supreme Court case, reference Resecession of Quebec, 1998, 2 SCR 217, the court affirmed that the rule of law is a foundational constitutional principle. It ensures that government action must be lawful, rational, and consistent with justice, not arbitrary or rooted in political convenience. But more importantly, the rule of law is not created by the government. It constrains the government. It flows from higher sources, including natural law and international law, and binds the state to operate within lawful and just limits. 2. The Canadian Charter and the Principles of Justice. The Canadian Charter of Rights and Freedoms is part of the Constitution Act 1982 and codifies the rights and freedoms Canadians are entitled to. These rights are not granted by the government, they are recognized and protected against state interference. Sections 7 to 15 of the Charter, in particular, embody what are known as the principles of fundamental justice. These include the right to life, liberty, and security of the person. Section 7, the right to not be subjected to cruel and unusual treatment or punishment. Section 12, equality before and under the law. Section 15. These provisions are not open to arbitrary legislative override. They are grounded in deeper principles, many of which reflect Canada's international obligations, particularly under the International Covenant on Civil and Political Rights, ICCPR. The ICCPR contains non-derogable rights such as Article 16, recognition before the law, and Article 18, freedom of thought, conscience, and religion, which must be upheld under all circumstances, even during national emergencies. Absolute rights and the obligation to stand under them. Absolute rights are not mere civil liberties. They are inalienable, universal, and binding upon all state actors. They are not contingent on government policy, public opinion, or bureaucratic interpretation. However, the key distinction lies here. Absolute rights must be claimed and exercised. If they are ignored, waived, or abandoned through inaction, the government will default to imposing statutory obligations that override your natural and international standing. This is not merely a matter of legal theory. It is a systemic operation. Canadian law operates on presumption and registration. If you do not assert your status as a living natural person, you will be treated as a statutory individual under regulatory regimes. If you do not challenge overreaching impositions, they become default obligations. If you do not invoke the Charter or international law in court, the court will apply statutory interpretation alone. Canada's legal system does not voluntarily protect your absolute rights. You must activate the operations of law that compel it to do so, accessing the operations of law that defend absolute rights. The operations of law that protect absolute rights are embedded in multiple layers. A. The Charter as a shield. The Charter functions not as a gift from the government, but as a barrier against it. For example, if a statutory law compels licensing, registration, or recognition that interferes with your conscience or status, Section 2, freedom of conscience, and Section 7, liberty, can be invoked. If your legal personhood is denied, unless you register with a government database, you can invoke ICCPR Article 16 and Charter Section 7 in tandem. B. The ICCPR, as a binding framework, Canada ratified the ICCPR in 1976. This creates binding legal obligations under international law. These obligations are not suggestions, they are enforceable rights. Relevant articles include Article 1, right to self-determination and free use of resources. Article 16, right to recognition before the law. Article 18, freedom of thought, conscience, and religion. Article 2 to 3, right to an effective remedy when rights are violated. These rights cannot be suspended, limited, or overridden, yet they are routinely ignored in administrative and judicial settings unless they are explicitly invoked. C. The Vienna Convention on the Law of Treaties, VCLT. Article 27 of the VCLT states, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. This means Canadian legislation cannot override ICCPR obligations. If they conflict, the international obligation prevails. 5. Practical steps to assert absolute rights in Canada. Knowing is not enough. You must act. Here is how. A. Stand on the record when engaging with government bodies or courts. Clearly state that you are standing on your absolute rights under international law, not seeking permission. B. Invoke the ICCPR and the Charter together use international law with domestic law. For example, this statutory requirement violates Article 18 of the ICCPR and Section 2A of the Charter. 6. The risk of passive compliance. What happens if you do nothing? The answer is clear. The government will continue to layer obligations on you. More licenses, more registrations, more statutory identity constructs, less room to exercise conscience, self-determination, or freedom. Statutory obligation expands until it is lawfully challenged. If you fail to stand on your rights, you will be deemed to have accepted your role as a statutory subject, a creature of administrative control. This is how natural persons are converted into managed entities. The role of the judiciary and public officials. Under both the Charter and international law, public officials and judges are under a duty to uphold rights, not violate them, to ensure remedies, not dismiss them, to operate under law, not political directives. The ethical principles for judges in Canada state that judges must act with integrity, independence, and fidelity to the law. This includes international law, which is presumed to be incorporated into domestic interpretation unless explicitly excluded, which peremptory norms cannot be. Conclusion: claim, stand, and activate. You are not powerless under the rule of law. In fact, it is the government that is restrained by the Charter, by the ICCPR, by the Vienna Convention, and by the principles of justice. But rights that are not claimed are treated as void. To live as a free individual under the rule of law in Canada, you must know the difference between statutory obligation and absolute rights. Understand that rights are exercised, not granted. Recognize that international law is supreme over conflicting statutes. Assert your standing clearly and consistently. This is not a protest. It is not rebellion. It is the lawful invocation of the highest legal order Canada is bound to. So long as you act within that truth, you do not stand alone. You stand under the rule of law, and that is where freedom begins. At the heart of lawful governance lies a profound yet often overlooked principle. Recognition is the gateway to standing under the rule of law in full capacity. It is not merely an administrative act or legal technicality. It is an invocation of truth that transforms one's legal position from that of a passive subject to an active, rights-bearing individual. In the context of Canada's obligations under both domestic and international law, a claim of recognition is the means by which one signals awareness of the government's bounded authority and insists on the full restoration of their absolute rights. It is the lawful countermeasure to a legal system that defaults to statutory constructs unless challenged. This write-up explores the legal, philosophical, and operational meaning of making a claim of recognition, how it interfaces with executive and judicial powers, and how it disables the state's presumption of lawful authority to reduce an individual to a statutory creature. More importantly, It shows how the claim of recognition is not simply a personal affirmation. It is a legal and moral signal that shifts the burden back to the state and forces an acknowledgement of international obligations. 1. What is a claim of recognition? A claim of recognition is a lawful declaration that you are aware of your natural and absolute rights. You do not accept reduction to a statutory persona without lawful justification. You acknowledge the obligations of the state under international law, including non-derogable norms. You withdraw presumed consent to any legal fiction or construct that limits your natural legal capacity. In essence, it is your formal recognition of their obligations, not their recognition of your existence. It is a reversal of power. The state no longer holds the exclusive authority to define your legal status. You do. The legal framework that supports this claim: A. International law, ICCPR, and just Cogens under the International Covenant on Civil and Political Rights, ICCPR. Canada is bound to uphold rights such as Article 16, the right to recognition as a person before the law; Article 18, freedom of thought, conscience, and religion; Article 2(1), the duty to respect and ensure all rights; Article 2(3), the right to an effective remedy for violations. These are not aspirational, they are binding. No act of Parliament, statutory regulation, or administrative policy can override them. Your claim of recognition operates within this superior legal order. B. The Vienna Convention on the Law of Treaties, VCLT. Article 27 of the VCLT declares, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. Therefore, the Canadian government cannot lawfully justify denial of recognition by citing domestic statutes. C. The Canadian Charter of Rights and Freedoms. While the Charter protects fundamental rights domestically, it is also rooted in the principles of international law. Section 26 of the Charter recognizes the existence of other rights beyond those explicitly listed. Section 52 establishes the Constitution as the supreme law of Canada, rendering any inconsistent law of no force or effect. When you make a claim of recognition, you are asserting a constitutional and international position, not making a personal plea. Why the claim of recognition is necessary. In the absence of a clear and direct claim, the legal system operates on a set of assumptions: that you accept being governed as a statutory individual, that you have consented, either passively or through silence, to laws that reduce your capacity, that your status is a creature of registration, not a being of inherent rights. These presumptions form the color of right the government uses to enforce authority over you. Color of right means a belief or assumption of lawful entitlement, even when no lawful basis exists. The state assumes authority until you revoke its foundation. Making a claim of recognition removes this color by declaring that you are aware of the government's limits, asserting that any further imposition must be justified under international and constitutional law, reframing your interaction with the state as a relationship between rights holder and duty bearer, not ruler and subject. 4. The statutory creature versus the natural person. A statutory creature is not a derogatory term. It is a legal classification. It refers to a legal entity brought into existence through birth registration, citizenship, declarations, social insurance enrollment, driver licensing, and other administrative constructs. These are tools of state management. However, when unchallenged, they become instruments of control. The government does not need to overtly strip your rights. It simply conditions your access to them upon compliance with statutory forms. This creates a paradox. You are free only if you submit to the system's control of your identity. Your rights are conditional on registration, not recognition. The claim of recognition breaks this loop. It reasserts your status as a natural person under the rule of law, not as a managed asset of the state. Communicating the claim to executive and judicial powers, the claim of recognition must be directed toward the branches of government that exercise authority. A. Executive power ministers, agencies, and public officers derive their authority from legislative acts. When you serve notice to the executive, you are reminding them of their obligation to comply with the Charter and international law. You are asserting that they must justify their actions not just under statutes, but under the rule of law. You are creating recorded awareness that their continued imposition may constitute a violation of peremptory norms. B. Judicial power. Judges are not permitted to ignore international obligations when rights are invoked. The Supreme Court has held that international law is part of the interpretive context of Canadian law. Baker v. Canada, 1999, 2 SCR 817. By submitting a claim of recognition to the judiciary, you are placing the court on notice that it must adjudicate with full awareness of its obligations under the ICCPR. You are invoking peremptory norms, which the court cannot override. You are requiring the court to distinguish between statutory assumption and recognized legal capacity. 6. The structure of a proper claim of recognition. To be effective, a claim of recognition should contain your declaration of awareness. Acknowledge that you understand the distinction between statutory and natural legal identity. Statement of international rights refer to specific articles in the ICCPR and the Vienna Convention. Rejection of color of right state that no statutory assumption can override your international legal status. Notice to the state. Affirm that the government is obligated to respect your status under international law. Demand for conformity. Require all future interactions with state entities to conform to peremptory norms, preservation of record file, or serve the claim where it will become a matter of public and legal record. Impact of a claim of recognition. Once on the record, your claim has multiple legal and strategic effects. It voids presumptions of submission to statutory constructs. It limits enforcement powers against you unless the state can justify its action under international law. It creates accountability. If your rights are violated afterward, the state's knowledge of your standing is no longer deniable. It opens the door to national and international remedy mechanisms. You are no longer invisible to the law. You are legally illuminated. 8. The ethical and spiritual significance beyond law. Your claim of recognition is a spiritual declaration that you see yourself as a being of conscience, that you reject all attempts to reduce your identity to a managed resource, that you affirm your place within a lawful order that transcends statute. This is not a rebellion. It is the highest form of peace, standing within law without subjugation. Conclusion: recognition reclaims capacity. A claim of recognition is more than an action. It is a legal, ethical, and spiritual shift. It informs the state that its color of right has expired and that you are not a statutory creature to be molded, taxed, or denied at will. You are a natural person under the rule of law, standing on peremptory norms and invoking the supremacy of international obligations. Governments do not limit themselves. Courts do not seek out violations. Recognition is how you awaken the dormant obligation of the state. By claiming recognition, you reclaim capacity, the right to act, to speak, to challenge, and to live in full alignment with the law above law. This is the awakening the system fears, and it begins with a simple truth: you are not theirs to manage. Visit eternallyaware.com to find out more.